I got a lot of problems with you people. I'm going to air all my grievances tonight. I'm going to launch them. I've been down here 6 of the last 7 days. I'm excited. Yeah. Yeah, we had baseball from Thursday till today. Good. Deal.
No, he's at,
Discussion of this, is this when he's gonna start, or is
no,
he doing that at the end?
he's at the very end.
Okay, I just saw it.
He's, yeah, no, he's right here. Ready?
No, I didn't.
Good evening and welcome to the Brookings County Planning and Zoning Commission meeting. This meeting is being recorded, televised, and viewable on Swiftail Channel 19, ITC Channel 168, or the Brookings County YouTube channel. And I'll call this meeting to order. Approval of minutes. Is there a motion?
So moved.
Motion by Diedrich. Second by Erickson. All those in favor?
Aye.
Motion passes. Items to be added to the agenda by commission members or staff.
Mr. Chair, I'd like to add an item. I think, whoa, I'm not sure where in the agenda we'll have the item, but let's add the item for motion to reconsider previous action on an amendment to the joint board.
And
Thank
me
you.
and Richard both will have staff reports other than that, and it falls on department head, so we're good. Thank you.
Okay. Agenda item 4 is invitation for citizens to schedule a little time with commission for an item not listed. Seeing none. Disclosure of conflicts of interest. I will be recusing myself from 2022 Variance 015. Neil.
I'll be recusing myself as well for the Brian item.
Okay. So we'll stop 6. Okay. Is there any other conflicts of interest? Seeing none, motion for approval of agenda.
So moved.
Motion by Vanderwall, second by Troyan. All in favor?
Aye.
Motion passes. We'll now convene as the Brookings County Planning and Zoning Commission. I now call this meeting to order. I would like to welcome those in attendance at tonight's meeting. The Brookings County Planning Commission is a 9-member commission whose function is to recommend approval or disapproval of land use plans, zoning ordinances, subdivision plats, and amendments thereof to the Brookings County Commission. The commission makes its recommendation based on the adopted comprehensive plan for the physical development of the unincorporated areas of Brookings County. As a matter of policy, all motions are to be made in a positive. After a motion is moved and seconded, it is open for debate. Those supporting the motion shall in turn give their reasons. Those opposing the motion shall then offer their reasons. After everyone has been given a chance to be heard, the commission shall recommend approval or disapproval based on the testimony and information presented. A simple majority vote of a quorum of members of the Planning and Zoning Board in attendance is required to forward a recommendation. agenda item 2022 Plat 013, plat of Lot 1, Sur Addition in the southwest 1/4 of Section 4, Township 109 North, Range 48W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion?
Second.
Motion by Vanderwall, second by Diedrich. Richard, would you read the staff report?
Yes, the Sewer family is platting off a 60.8 acres of farm ground due to the irregular shape, and access will be off 180th Avenue or 205th Street. Both are Parnell Township gravel roads, and it meets the platting requirements in the 2016 comprehensive plan for the unincorporated rural area. Here is the plat. Lot 1 right here in the southwest corner. Here is the beacon map showing what is being platted off, this pasture. What's pasture grassland, but this is the farmland up to the north here. So this is an existing building site. So this is what they're platting off right here, just due to the irregular shape. And the applicant is not here this evening, and that's all that I have.
Thank you. The applicant is not here. I will now move to the public portion of the hearing. Is there anybody in the audience that is for this? Seeing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I will now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Richard, would you call vote?
Bartley,
Aye.
Erickson, Gadsky, Dietrich,
Aye.
Kleinjohn,
Aye.
Vanderwall,
Aye.
Troyan,
Aye.
Storhog,
Aye.
and Ford.
Aye.
Motion passes.
Moving on, agenda item 2022, Plat 014, plat of Lot 1, Sur Addition in the southeast 1/4 of Section 5, Township 109 North, Range 48W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Diedrich,
Second.
second by Kleinjohn. Richard, would you read the staff report?
Yep. The Sewer family again is planting off 48.7 acres of farm ground due to the irregular shape again. This will have access off 180th Avenue, which is a Parnell Township gravel road, and it meets the comprehensive plan requirements. Here it is right here. This is the plat. There's the plat laid on the beacon map. It's going north of the existing farmstead up grassland and non-tillable ground area, I guess we'll put it that way. Here's the beacon map. And like I said previously, the applicant is not here this evening. And that's all that I have.
With the applicant not here, I'll move to the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call the vote?
Erickson, Gadsky, Dietrich,
Aye.
Kleinjohn,
Aye.
Vanderwall,
Aye.
Troyan,
Aye.
Storhog,
Aye.
Bartley,
Aye.
and Ford.
Aye.
Motion passed.
Moving on, agenda item 2022, Plat 016, plat of Lot 47A of the first edition of the Lake Ponset Heights subdivision, Lot 2, Section 5, Township 112 North, Range 52W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion?
Did you skip 50?
Did I? Hold on, back up. How about we do 2022 Plat 015? Plat of Tract 1 of Langland Edition in the northwest 1/4 of Section 32, Township 111 North, Range 52W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Vanderwall,
Second.
second by Diedrich. Richard, would you read the staff report?
Yep, 2022 Plat 015. John Albright is platting off an 8.4 acre existing homestead from the rest of the 160 acres he owns. The shape is irregular and it'll have access off 207th Street, which is also known as Brookings County Blacktop Road Number 8. And it does meet the plating requirements of the 2016 Comprehensive Plan. It's being platted off for a family member. There's a existing building site around the perimeter of the trees. There's the beacon map showing where it is. And that's, the applicant is not here this evening, and that's all that I have.
Thank you. With the applicant not here, I'll now open the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call roll?
Gatsky. Dietrich.
Aye.
Klein John.
Aye.
Vanderwall.
Aye.
Troyan.
Aye.
Storhog.
Aye.
Bartley.
Aye.
Erickson. And Ford.
Aye.
Motion passes.
Agenda item 2022, Plat 016, plat of Lot 47A of the first edition of Lake Ponset Heights subdivision in Lot 2, Section 5, Township 112 North, Range 52W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion? Motion by Troyan,
Second.
second by Vanderwall. Richard, would you read the staff report?
Yep, 2022, Plat 016. Tim Bjorklund and John Haynes are replatting their existing lot down to the shoreline. Lake Ponset Heights First Edition was originally platted on September 1st, 1922, and it meets the comprehensive plan for existing use for the developed lakes on page 11 of the 2016 comprehensive plan. There's the plat. This is where the original plat was. They just extended it out to the end of the lake shore, just like we've done with several other ones up in that area. This is proposed plat on the beacon map. This is where the existing plat is right here, this blue line that goes out to the lake shore right there. Just gives the landowner the property where the house sits on. Here's the beacon map. And the applicant is not here this evening, and that's all that I have.
With the applicant not here, I'll now open the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Hearing none, Richard, would you call a vote?
Yes, Dietrich.
Aye.
Klein John.
Aye.
Vanderwall.
Aye.
Troyan.
Aye.
Storhog.
Aye.
Bartley.
Aye.
Erickson. Gatsky. And Ford.
Aye.
Motion passed.
Agenda item 2022, Plat 017. Plat of blocks 1, 2, 3, and 4, Langham Edition in the southwest 1/4 of the west half of the southeast 1/4 of Section 18, Township 109 North, Range 51W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Diedrich,
Second.
second by Bartley. Richard, would you read the staff report?
Yep, 2022, Plat 017. Don Langham is planning off Block 1, which is a 5.58 acre existing homestead. Block 2 is 143.95 acres of farmland, pasture and grassland. Block 3 is 57.08 acres of pasture and grassland. Block 4 is 16.95 acres of pasture and grass. Residents cannot be built on Block 4 as it is less than 35 acres. The shapes of the parcels are irregular and will have access off 460th Avenue and 217th Street, which are both Oslo Township gravel roads, and it meets the plating requirements of the 2016 comprehensive plan. Here's the plat with the various blocks on there. Block 1, the existing homestead. Block 2, 3, and 4. There's the beacon map showing the various blocks. Homestead, Block 2, Block 3 and Block 4. There's the beacon map with this 1/4 and this and the other 80 also right here. So that's all I have, and the applicant is not here this evening.
With the applicant not here, I'll now open the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call a vote?
Klein John. Aye. Vanderwall.
Aye.
Troyan.
Aye.
Starhog.
Aye.
Bartley.
Aye.
Erickson. Gatsky. Dietrich.
Aye.
And Ford.
Aye.
Motion passes.
Agenda item 2022, Plat 018, plat of Block 1, Jensen Second Edition, in the northwest 1/4 of Section 9, Township 109 North, Range 48W of the 5th Primary Meridian, Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Vanderwall,
Second.
second by Troyan. Richard, would you read the staff report?
Yes. 2022 Plat 018, Lawrence Jensen is platting off a 68.16 acres of farmland just due to the irregular shape with the railroad tracks going through the property. Access will be off 480th Avenue, which is a Parnell Township gravel road, and it meets the platting requirements of a 2016 comprehensive plan. Here's the plat. Railroad tracks going this way, as you'll see on the map. This is the irregular shape. This is the Block 1, 68 acres. Here's the plat on the beacon map. This is right here, the railroad track south of the tracks area. There's the beacon map showing both parcels, and that's all that I have, and the applicant is not here this evening.
With the applicant not here, I'll move to the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call a vote?
Vanderwall.
Aye.
Troyan.
Aye.
Starhog.
Aye.
Bartley.
Aye.
Erickson. Gatsky. Dietrich.
Aye.
Kleinjohn.
Aye.
And Ford.
Aye.
Motion passes.
Moving on, agenda item 2022, Plat 019, plat of Block 1, Ginger Edition, in the northwest 1/4 of Section 7, Township 112 North, Range 47W of the 5th Primary in Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Diedrich,
Second.
second by Vanderwall. Richard, would you read the staff report?
Yes, 2022 Plat 019. The Troyan family is planting off an 81.61 acres of farm ground and pasture and grassland. It is 81 acres are irregularly shaped and located in 3 separate parcels. And access will be off 197th Street, which is also known as Brookings County Blacktop Road number 40. That does meet the platting requirements for our 2016 comprehensive plan. Here's the plat. This is the 3 separate parcels, here, here, and over here. And we'll see that on the beacon maps when we get the overlay on there. This is one parcel, this is the other parcel, and this is the third parcel, combining them all together into one block there. Here's the beacon map. Showing the north parcel. This will be the southwest parcel. And this is the southeast parcel. That's all that I have, and the applicant is not here this evening.
With the applicant not here, I'll move to the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I will now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call the vote?
Starhog.
Aye.
Bartley.
Aye.
Erickson. Gatsky.
He recused himself from that.
Oh, I'm sorry. Yep. Thank you. Dietrich,
Aye.
Kleinjohn,
Aye.
Vanderwall,
Aye.
and Ford.
Aye.
Motion passes.
Agenda item 2022, Plat 020, plat of lots 1B and 1C of Goodfellow Edition in the north one half of the northeast 1/4 of Section 18, Township 111 North, Range 51W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Diedrich.
Second.
Who had that? Second by Kleinjohn. Richard, would you read staff report?
Yes, 2022, Plat 020. Vance Goodfellow is subdividing the 35.5 acres he owns into Lot B, which contains 32.1 acres, and Lot C, which is 3.4 acres. Lot C is in the Lake Park zoning district, and Lot B is in the agricultural district. And a residence cannot be built on Lot 1B, as it does not meet the 35-acre requirement. It does meet the comprehensive plan for the agricultural use area and the development in the Lake Park district. This is the plat here. This is the existing lot. This is what they're subdividing off into Lot 1A, 1C, the 3.4 acres. This is Lot B, the rest of the property around that, which is 32 acres. Yeah, Lot 1C right here adjoins the Owl Lodge area around there, and Lot 1B is the balance of that. So that's all that I have, and the applicant is not here this evening.
With the applicant not here, I'll move to the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public portion of the hearing. Is there additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call the vote?
Bartley,
Aye.
Erickson, Gatsky, Dietrich,
Aye.
Kleinjohn,
Aye.
Vanderwall,
Aye.
Troyan,
Aye.
Sturhog,
Aye.
and Ford.
Aye.
Motion passes.
Moving on, agenda item 2022, Plat 021, plat of Tract 1 of BMU WTP Edition in the northwest 1/4 of the southwest 1/4 of Section 20, Township 110 North, Range 49W of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Vanderwall. Second by Troyan. Richard, would you read staff report?
At 2022, Plat 021, Brookings Municipal Utilities is replatting Lot 1 of Hanson Edition in the northwest 1/4, except Lot H1 and H2 in Section 20, Township 110 North, Range 49 West, and Lot 1 of CKS Partners Edition in the southwest 1/4 of Section 20, Township 110 North, Range 49 West into one plat. The combining of the two parcels was a stipulation when Lot 1 of the CKS partnership was approved. The combined plat has highway access off 34th Avenue, and this is the future site of the Brookings Municipal Utilities water treatment plant. And it does meet the comprehensive plan for the agricultural use area and the joint jurisdictional area. This is the existing Hanson Track 1 that went originally across this dotted line right here. This is the other Track 1 of CKS Partnership, I believe it was. Long, narrow shape along the west side. There's the new plat on the beacon map. There's the original one there, and then the proposal was down along this track right here. That's all that I have, and the applicants are not here this evening.
With the applicant not here, I'll now open the public hearing. Is there anybody in the audience that is for this? Seeing none, is there anybody in the audience that is opposed to this? Seeing none, I'll now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call a vote?
Erickson, Gatsky, Dietrich,
Aye.
Kleinjohn,
Aye.
Vanderwall,
Aye.
Troyan,
Aye.
Storhog,
Aye.
Bartley,
Aye.
and Ford.
Aye.
Motion passed.
Moving on, agenda item 2022, plat 022, plat of lot 1 of Smallfield Edition in the northeast 1/4 of section 7, township 109 north, range 47W of the 5th primary in Brookings County, South Dakota. Is there a motion?
Don't move.
Motion by Diedrich. Second by Erickson. Richard, would you read staff report?
Yes, plat 022, plat 022. Smallfield Family Trust is platting off a 37.5 acre existing homestead and farm ground from the rest of the 159 acres that they own. The shape of the parcel is irregular and it meets the platting requirements of the 2016 comprehensive plan. Here is the plat, showing the irregular shape on that. Here is the plat on the beacon map. Around the building site, jogs to the west a little bit. Mainly it's the pasture and grassland they're subdividing off. Here's the beacon map showing the whole quarter. And that's all that I have, and the applicant is not here this evening.
The applicant not here, I'll move to the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I will now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call the vote?
Gatsky, Dietrich,
Aye.
Kleinjohn,
Aye.
Vanderwall,
Aye.
Troyan,
Aye.
Storhog,
Aye.
Bartley,
Aye.
Erickson, and Ford.
Aye.
Motion passed.
Moving on, agenda item 2022, plat 023, plat of lot 1 and 2 of Cooper Edition in government lots 4, 5, 6, and 7 of section 6, township 110 north, range 50W of the 5th primary in Brookings County, South Dakota. Is there a motion?
So move.
Motion by Vanderwall. Second by Erickson. Richard, would you read the staff report?
Yes, 2022, plat 023, James A. Cooper is platting off lot 1, which is a 20-acre existing building site. And lot 2 is 87.8 acres of grassland. The parcels are irregular shape, and it meets the platting requirements of the 2016 comprehensive plan. Here is the plat. This is lot 2. Comes down, there's 3 different parcels here also. It comes down this way, jogs back just a little bottleneck right here to come back up, catch the rest of this. This is the 20-acre building site right here, this irregular shape. And so this all is one piece from about a mile long outside of the building site right there. We'll show it better on the beacon map. This is lot 1, the building site. You didn't put that on there. This is the north parcel of that. There's 3 different individual parcels that. And here's the parcel with the building site. And here's the south long parcel. So he's taking 20 acres out of this site right here where the building is. And the rest of these will all be connected into one parcel. That's all that I have, and the applicant is not here this evening.
With the applicant not here, I'll move to the public portion of the hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call a vote?
Yes, Dietrich,
Aye.
Kleinjohn,
Aye.
Vanderwall,
Aye.
Troyan,
Aye.
Storhog,
Aye.
Bartley,
Aye.
Erickson, Gatsky, and Ford.
Aye.
Motion passed.
Moving on, agenda item 2022, Plat 024, plat of Lot 1 of Risty Farms Edition and Government Lot 3 of the south half of the northwest 1/4 of Section 4, Township 109 North, Range 52W of the 5th Primary, Brookings County, South Dakota. Is there a motion?
Don't move.
Motion by Diedrich, second by Erickson. Richard, would you read the staff report?
Yes, 2022 Plat 024, Risty Farms is platting off Lot 1, which contains 36.2 acres of grassland with a historical building site. The parcels are irregular in shape and is large enough to build a residence on, as it is greater than 35 acres, and it does meet the platting requirements of the 2016 comprehensive plan. There's the plat showing the long irregular shape there. There's the plat on the beacon map. Went from 217th Street, I believe it is, down to just the tip of Lake Sinai right there. This is a historical site. Historical homestead was right here on that. There's the whole quarter. This is what we platted off of there. And that's all that I have, and the applicant is not here this evening.
With the applicant not here, I'll move right to the public hearing. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I will now close the public portion of the hearing. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call the vote?
Vanderwall,
Aye.
Troyan,
Aye.
Storhog,
Aye.
Bartley,
Aye.
Erickson, Gatsky, Dietrich,
Aye.
Kleinjohn,
Aye.
and Ford.
Aye.
Motion passed.
We will now convene as the Brookings County Board of Adjustment. The Board of Adjustment is a 9-member board which has the power to hear requests for variances, conditional use, and appeals from non-ministerial decisions of the zoning officer. The concurring vote of 2/3 of a full board membership of the board, 6 votes is necessary for approval of a variance or an appeal of the zoning officer. The concurring vote of a simple majority of those board members present in voting is necessary for approval of a conditional use permit. In accordance with Robert's Rules of Order, we require a motion to approve a request before it can be debated. As a matter of policy, all motions are to be made in positive. Under the board's specific powers, granted to it by the state, shall authorize variances from zoning requirements where special conditions existing on the land will result in an unnecessary hardship for the applicant. Financial disadvantage to the property owner shall not constitute proof of an unnecessary hardship. I will recuse myself at this time. Mr. Kleinjohn.
Richard Ford has made an application, 2022 variant 015, to the Brookings County Board of Adjustment for a variant. Article 11, Section 11.01A Agricultural District, Area Regulation. Number 2, front yard. Minimum depth of the front yard shall be 100 feet. Corner lot will have 2 front yards. The property is described as the southeast quarter of Section 21. Township 112 North, Range 51 West, Preston Township, located at 46272 200th Street, Bruce, South Dakota, 57220. Do we have a motion?
So moved.
Okay, you read the staff report.
2022 variance 015, Richard Ford has applied for a front yard variance for a 60 by 128 by the 20-foot sidewall machine shed to be built 80 feet from the center of 200th Street, the variance of 53 feet. The required setback is 133. There are existing grain bins, a shed, and a driveway to a feedlot that is located on the east side of the existing trees that prevents the applicant from meeting the setback requirements. Public notices were published in the Brookings Register on July 19th and 26th, 2022, and the Volga Tribune on July 21st and 28th, 2022. And letters were sent to the adjoining landowners and the Preston Township chairman and clerk. Here's the variance request application. Here's the site map. Going 80 feet from the center of the road. Existing house is here. Grain bins are here. Sheds are down there. There's a driveway right in about in this area. Comes over. Just on the other side of there's trees right here. Then there's a feedlot right here on this side where this driveway comes. We'll see here. This is the proposed area. There's this house, existing bins, and shed, trees. A portion of them will stay. And here's the driveway coming back over to feedlot, which is located right here. This is looking east from the driveway, a clear view. This is looking towards the west, clear view that way also. This looking north down the driveway from 200th Street. There, this is looking towards the building location from 200th Street. This is, the wheel is at 80 feet from the center of 200th Street. They did have a stake out there. It's kind of hard to see right there, but they had existing stakes on the north end and the south end where the end of the proposed building would be, which is always nice to have out there so you can kind of see where that is. And the dog was pretty photogenic that day too. He liked my dog biscuits. On the end of the stake, north end would be right here. Proposed just on the north end of that evergreen trees. That's all that I have, and the applicant is here this evening.
Okay, the applicant can come forward. State your name.
Chad Ford for Rick Ford.
Have anything to add?
Richard summed it up pretty easy. If we go too far north, we'll run into the loadout for the feedlot.
Okay, we'll open public hearing. Are there any proponents to this issue?
We did receive comment from the Preston Township on that, and they had no objections to that. Read that here. Now, Barry Loomis, the chairman of Preston Township, called the zoning office at 1:15 p.m. regarding Richard Ford's 2022 Variant 015 request, stating that Preston Township has no objections to the variance request. Richard Haugen, Deputy Director, Brookings County Development Office. Those are all the comments that we had received.
Are there any opponents to the issue? Hearing none? Am I supposed to refer this back to you, or is that just?
No, I gotta go over the findings of that.
Okay.
I'll read the findings of facts here. Brookings County zoning variance 2022 variant 015, an application for a variance have been filed with the Brookings County Zoning Commission. Acting as a Brookings County Board of Adjustment, a copy of the application being attached here too. Such application being made by Richard Ford regarding the following real property. The southeast 1/4 of section 21, township 112 north, range 51 west, Lake Preston Township, located at 46272 200th Street, Bruce, South Dakota, 57220. After due notice, a public hearing have been held on the application on the 2nd day of August 2022. Number 1, Brookings County Board of Adjustment hereby finding that the strict application of the Brookings County zoning ordinance would produce undue hardship, that such hardship is not shared generally by the other properties in the zoning district in the same vicinity, that the authorization of such a variance will not be substantial detriment to the adjacent property, and the character of the district which will not be changed by the granting of the variance, and that the granting of such variance is based upon reasons of demonstrable and exceptional hardships as distinguished from variations for the purpose of convenience, profit, and caprice. Number 2, the Brookings County Board of Adjustment further finding that the condition of the situation or situation of the property concerned or intended use of the property is not so general or reoccurring of nature to make necessarily practicable the formulation of a general regulation to be adopted as an amendment to the zoning ordinance. Number 3, the Brookings County Board of Adjustment further finding that the written application of the petitioner demonstrates that special conditions and circumstances exist which shall peculiar to the land, structure, or buildings in the same district. That literal interpretation of the provisions of the Brookings County zoning ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same district under the terms of the ordinance, that the special conditions and circumstances do not result from the actions of the applicant, and that granting of the variance requested will not confer the applicant any special privilege that is denied by the ordinance to other lands, structures, or buildings in the same district. Number 4, the Brookings County Board of Adjustment finding that the reasons set forth in the application justify the granting of the variance, that the variance is the minimum variance that will make possible the reasonable use of the land, building, or structure, that granting of the variance will be in harmony with the general purpose and the intent of the Brookings County zoning ordinance, and will not be injurious to the neighborhood or otherwise detrimental to the public welfare. Number 5, the Brookings County Board of Adjustment further determines and conditions this variance upon the following special conditions or safeguards. A, shape and size of the building site. B, location of existing bins, shed, and existing driveway going to an open feedlot directly to the east of the proposed location. The Brookings County Board of Adjustment further, by at least 2/3 vote of its full membership, hereby grants the above petitioner variance for the above described real property as follows. Build a 60-foot by 128-foot pole shed with a 20-foot sidewall 80 feet from the center of 200th Street. This variance is specifically conditioned upon initial and continued compliance with all the conditions and safeguards in 5 above, and upon compliance with all applicable provisions of the Brookings County zoning ordinance. Zoning, if approved, the Brookings County zoning director is authorized to issue any required building permits for construction consistent with the terms of this variance. If this variance is not used within 3 years of the date granted, it shall be invalid. Now, one thing to add back up here, it didn't stay, would be Preston Township has no objections to the variance request.
Any additional comments or questions from the board?
Mr. Chairman, I concur with findings of fact.
Call the vote.
Yes. Vanderwall,
Aye.
Troyan,
Aye.
Storhog,
Aye.
Bartley,
Aye.
Erickson, Gatsky, Dietrich,
Aye.
and Kleinjohn.
Aye.
Motion passes.
Is this where we'd add in the added agenda item then, quick, before we do your training, or how do we do that?
a motion to rescind
We are,
or reconsider a previous motion that at our last meeting, an amendment that passed. It's not.
we added it at the beginning.
I added it at the beginning. May I just go ahead and explain where we're at here? There's a couple of options with this evening that we can go after. The actions that happened at the last meeting were within 30 days of this meeting, so it's appropriate to ask for a motion to reconsider the motion. That has to come from a prevailing side of the motion. In other words, so those who voted yes for the motion would have to make a motion to reconsider. It can be seconded by any other member of the board. At that time, the discussion can be had on reconsidering only, and then that vote would have to be a majority vote to reconsider. If that happens, then the motion's back on the floor to reconsider if it's going to be changed or passed or not passed. All right, so that's one option that could take place this evening. A second option that could take place this evening is a motion to rescind. A motion to rescind can be done within a quarter of the action, yearly quarter. That particular motion to rescind then can be made by anybody, simply because it's past the 30 days. It can be made by anybody. Again, it has to pass by a majority in order to be on there. But the addition of the motion to rescind also has to be published, that you're going to have that motion to rescind, so that the public has a right to come to that motion to rescind an action that was previously taken. I'm going to go back to that meeting for just a moment and describe what I saw happen. And Luke was there. Maybe he can correct me if my memory's not all that good. But because we passed a motion to amend it, and the city did not pass that same motion, everything stopped. In other words, we didn't pass the original motion, which was to move the joint jurisdiction ordinance forward. Is that correct?
Basically, what you have is diverging paths right now. In order to have a joint jurisdiction ordinance, both elected bodies have to approve the exact same ordinance. This board has recommended an ordinance that's slightly different than the version that the city has. So the two options that are available at this point without any further action from this board are, well, there's actually three, but if this board doesn't do anything else and just says commissioners and commissions, you figure it out, it's either A, the city commission would need to amend their ordinance the same way that the planning commission amended its ordinance, or and they could do that at the meeting, or the county commissioners would have to propose an amendment to put the property back into the joint jurisdiction area, at which point they'd have to hit pause, publish a notice for that specific amendment as well, vote on that amendment after a public hearing, and then vote on the ordinance again. Bottom line, it would be two public hearings for the county commissioners to make the ordinance back what it was before. It would be just something that the city commission could do to pull it down to this level. Or the other option is the planning commission decides, you know what, we'll just put it back to the way it was.
This planning commission.
This planning commission, yeah.
Then they could do that either with a motion to reconsider or a motion to rescind. The motion to rescind then has to have it published. It's not the same publishment as a motion to change it back. Is a completely new motion. It's not a motion to rescind. Motion to rescind rescinds that actual motion, and that motion can be rescinded within the quarter. The motion to reconsider has to be done within 30 days, and we're just under 30 days, so we don't have to. And the whole idea of this is, at this point in time, and I agree with Luke, somebody has to agree. But right now, it's gone to the two attorneys, the city's attorneys and the county's attorneys, to review and to come up with a compromise. It ain't going to happen very fast if they even want to tackle it at this point. I don't think neither one of us is very happy that it moves to them to come up with a compromise. The other issue that we have is as I look at the ordinance itself, it's important for me, having worked on it for a long time. There are an awful lot of other things in the ordinance that need to be passed. It needs to be passed, and we're operating in some gray areas that we'd like to get straight. And the rest of the ordinance, I think, looks pretty good. We may have some discussion on some housing things as we go along, but at the same time, if we keep delaying this, we could be another year or two out before we got this thing done. And right now, it's my feeling I would like to push this forward. I'm not as concerned about the motion that was made and whether it's passed and fails on each side. If we can't come to a quick compromise to either finish it off, I'm not going to make an argument for or against the amendment, okay? Because it's not appropriate at this point. Is there a desire from the board tonight to make a motion to reconsider? And that motion has to pass. And if it passes, then we can have discussion. We can have discussion on the motion to reconsider, whether we're going to do it or not, as long as it doesn't involve the motion itself, the amendment, just the motion to reconsider. If it passes and it takes a majority, then then the motion is being reconsidered, the original amendment is being reconsidered, and it can be voted up or down. Okay? That could happen tonight, and then that would move it forward because the city rejected the motion. However, we would have to have another joint meeting with the city to approve the ordinance as it was not amended. Our amendment failed on both sides, so we would be able to move forward at that point.
Chairman
Unless there's
Ford,
something else. Sure.
since it's perceived that I have a conflict of interest, I'm going to step out in the hallway while you guys discuss this, and then when it's done, come and get me.
So at this point, you have two options. We can motion to reconsider tonight. That has to pass, and then it could be discussed, and it could pass again, the second amendment, or it could be overturned, which would then move it back to the joint jurisdiction, having to meet one more time to approve the agenda as it was presented and not amended. The second one is if you want to go through the process to rescind or to make an entirely new motion to have two public hearings, which we could do also, but it does delay the process. Motion to rescind, we would publish it on the agenda for the next meeting. And then we could do that motion to rescind. Again, it has to pass, and again, you have to have the discussion. And at that point, then we would move it forward. And I don't have a problem with going 30 more days for that to allow us to have some conversations with the City Planning Commission, which I've sort of started to see if there's any way we can move it forward on their side. So anything you want to do is fine. If you do nothing tonight, nothing happens. And any member can make a motion to rescind, put on the agenda for next month. Any member can ask that it be put on the agenda. It's not a motion. Ask that it be put on the agenda for next month.
And we can reapproach it and re-vote on it just the way it is also, with a member recusing himself this time if need be, to clear up some things.
Whether he recuses himself really doesn't matter in the vote.
Okay.
Still a majority of members present.
Yep.
In this case, all of us. So I don't want to spring it on anybody that we need to do this tonight. You have an option to do it tonight if you desire. If you want to give it some time and make a motion to rescind and have it published in the agenda that we put out, we can do that at the next meeting.
Basically, this is our options: to reconsider or to redo it. And if you're not comfortable with where we're sitting at tonight, we can leave it alone until then. But if need be to reconsider, it'd be the time to do it and see what happens. Or we can do it next month or after that. It's just trying to move the process forward.
What did the state's attorney recommend with the conflict of interest issue?
His recommendation was because we didn't take official action on the entire ordinance, it's probably not a conflict that would stand the test of time if we were to file a suit. Of course, they're always looking for, are you going to file a challenge to it in a court action? And he didn't feel that he would ever take that court action, so that's the easiest way to say it. We as a board can determine whether we think it's a conflict of interest and vote on it. But that doesn't necessarily mean it. It could still go to a court case.
So I have a question regarding the person who recused themselves actually making the motion. And is that way back in the beginning of that? Is that the proper way
Either
to-
either in a reconsideration or a rescind, it doesn't matter. Anybody on the reconsideration, anybody that makes the motion has to be on the prevailing side that voted yes on this particular one. Had voted yes has to make that motion. Anybody else can second it, but somebody on the prevailing side who said yes has to make the motion to reconsider. If there's no motion to reconsider, then we're done, as far as tonight is concerned. The second option is then I could ask it to be put on the agenda for the next meeting as a motion to rescind instead of reconsider. If you want more time to talk to everybody involved.
So is there an avenue that we could just rerun the motion as it stands now with a different party making the motion?
The party making the motion doesn't matter, but when he has rescinded himself, the big thing is he voted. Where if he wouldn't vote this time, it would dissolve the conflict of interest. Right?
Right, he voluntarily rescinded or recused himself, so it doesn't matter that he made the motion last time. So anybody can make a motion to reconsider.
I think we're having a discussion about two different things.
Yeah.
The biggest thing right now is whether or not we can rescind or reconsider it. I think what you're asking is, if we reconsider it, bring it up for discussion, is there a problem with making that motion again, as long as Mr. Gatsky has recused himself and then voting on it?
And there's not a problem with doing that. That is
No.
an option that we have on the table.
Just trying to get all on the same page and make sure we take the right avenue.
Well, and that's what,
I'll go ahead and chime in. I'm going to throw a lot at you here. First of all, a lot of what I'm going to be talking about in a few minutes is more about public, quasi-public, it's more about quasi-public or quasi-judicial proceedings, which is different than what you're talking about here. You're talking about a legislative thing where you've made a law or made a recommendation on a law in this case, which is what the state's attorney was getting at, is that, since it's not actually the action of enacting the law, that's probably not a case that the way it sounded he would take up, but it's not to say someone wouldn't. And when you're talking about it as the basis of an ordinance that makes a lot of decisions, the concern is that someone may bring that up. I'm reading between the lines. That's what I'm thinking he's thinking at that point. So if the ultimate concern is, if everyone's still on the same page thinking that this is what it needs to be, but you're concerned about the legal argument of it, perhaps the right avenue would be reconsider, then revote without that individual there, and that would probably take care of that issue, because you're not going to take the actual motion off the table. The motion will be back. You just revote without that individual there. If it's not that much of a concern, then just leave it be. Or if you decide, heck, maybe we shouldn't have made that change, well, then you go ahead and vote to, at that point you'd change your mind. But the bottom line is that realistically the question is not necessarily about the policy. It could be, but it's not necessarily about the policy. It's more about making sure that decision is going to be as legally sturdy as possible, which I'm not going to make an argument as to whether or not it is. I will point out some things that in a little bit that are on a sheet that say that you've got a lot more leeway on lawmaking than you do on administrative when it comes to that sort of thing.
One other thing I would consider, if we're concerned that the conflict of interest individual wants to weigh in on this a second time, then the motion to rescind allows that publication of that. It'll be on the agenda. And if you don't think he has a conflict of interest, you can make that clear. We can vote as a body whether we consider it to be a conflict or not. If we vote that it's not, then he can join the discussion. He can also voluntarily recuse himself at that time. This is, again, sprung on him tonight, so I don't want to give the impression that we don't want Brian to weigh in. Okay? So if you go to the rescind motion, it goes on the next agenda, which I would probably ask it to be put there. And he can either decide to recuse himself or not if he chooses not to. And a member says, I challenge that decision. Then you have a discussion and a vote whether he is, this board thinks he's in violation or not. If he's not, he continues to sit and can vote and have discussion. If the majority of the board says he has a conflict, then he cannot. But that gets into a legal position. If you recuse him by a board vote, he can challenge that in a civil case. So that gets a little difficult. I said, my thought is if we rescind and the person decides he doesn't have a conflict, we probably are not going to challenge it. As clear as I can make it.
Clear as mud.
It gets deep, and I didn't mean to take your time.
There is no clear.
So you don't have to do anything tonight. We can move on to Luke's presentation.
Basically, we laid out the options. And it's rescind or revote with Brian recusing himself, and see how it goes from there. Or is this, unfortunately, in the name of progress, is this something we want to tackle tonight, or think about till next month and see where we get?
Wouldn't need any action. Other than if somebody wanted to make the motion to reconsider, then we could do so, but we don't.
Yep, to have it on.
No.
Okay.
No, I could ask you to put it on the agenda, a motion to rescind that motion. And you'd have to put it on the agenda as a request, but then it's published, okay? Because it's a different action than reconsider.
Yeah, so what you're getting at is it would be on the agenda, you do a public notice, and then before you even opened a public hearing, you would have the motion. And if it dies for lack of second, we don't even have a public hearing. And if the motion gets a second, then you hold a public hearing on rescinding that motion, and then you would vote after that.
Research on the public hearing part of it. Not sure that would be required.
Oh, you're right, since you already held a public hearing.
Yeah.
Yeah, you may not have to, that's a good point.
The hearing is closed
Yeah.
already.
Hearing has been closed, so yeah,
You would at least have discussion on it, you're right.
we would have a discussion.
Yeah.
As a board. And if there's no motion to rescind at that point, it stays as it is.
Is there a motion for something? Unfortunately, it falls on the 5 yes, well, rescind can come from anybody,
Right.
But the reconsider has to come from the 5 yes
Prevailing-
votes,
Prevailing side. Two yes votes.
because I can't.
No. You weren't on the prevailing side.
Yeah, he was on.
I was on
you
the
could
prevailing
step down
side.
as the chair. If you wanted to make the motion, you could step down.
I could step down as the chair and then make the motion.
Good.
To recon,
I think at any point in time, the chair can can step down as the chair, can't they?
I would tell you, my own suggestion on that is that you are just as shaky a ground on that as you are on the motion you've got.
Okay.
I don't know that I would do that.
All right, then, I'll plan on doing the research and doing the rescind motion so that we're correct for our next meeting. That doesn't need approval, just, we have a lack of a motion to reconsider, so it'll be a motion to rescind that I'll bring to the next meeting.
that doesn't mean we're necessarily doing it, it's just getting it to next meeting to talk about. Where we can rescind it next meeting with a hearing, or reconsider it. We can reconsider it with a rescind deal also.
I don't think we can reconsider it. We can only rescind it.
Right, reconsider would be, this is the last go
So-
at that.
Yeah.
But
That has to happen within 30 days or the next meeting.
Is there
In
an
this
option we
case.
could make a motion to table it?
No, cause
No.
we run out of the 30 days time.
Gotcha.
You could, but it doesn't do any good because we're out of the next meeting and,
You might as well go to rescind at that point.
yeah,
go to the rescind and then we
Let's go to
can,
the next meeting.
You either need to take action tonight to reconsider, or the next meeting to rescind it.
What would you want to table it for?
Just to have more time to
wrap
think
your head
about it, I guess.
Because correct me if I'm wrong, Luke, he could reconsider it and then table the motion after it's reconsidered.
well, that is a good question, because I was actually thinking the same thing, that the motion to reconsider could
If it
potentially
passed.
be made. I'm gonna go to someone with slightly more experience on the reconsider than me. Does the vote have to occur within that
You would have to
30 days?
table to another meeting is one thing, tabling it indefinitely and it's done.
My own thought is that if it's your intent to think on it, I think from an efficacy standpoint, you can probably accomplish the same thing through rescinding as you can by doing that. So
Exactly.
if you're not ready to vote on it today or to do that, you can probably do the same thing through rescinding. The only thing I will caution you on the rescinding is that there is an avenue if you take that vote away. I think we are going to have to ask the question of if we put ourselves back into public hearing phase once we have rescinded an action on that, if we have to go back to public hearing. Just make sure you ask your state's attorney about that before that happens. I don't think that anyone needs to worry about the idea of holding another public hearing, because honestly, it's what the job is. So I don't want to say that you should make a motion and be afraid of a public hearing. So that's the bottom line, is that would be the only benefit to doing the table action here. I think you can do the same thing through rescinding it.
And would that be a joint hearing or just with our board?
Well, that's my point, is that we gotta go through peel one layer of the onion and then two, if that's the case.
Right.
I'm not even sure we need to do one, but I think we've got to pose that question if that does happen. So, looks like we're going to be moving on tonight.
I'm fine.
Okay.
so we're gonna, what was that now? We're gonna rescind it, motion to rescind for next meeting to get it on the agenda and then we can come back with it.
We don't need a motion to put it on the agenda.
Okay,
Just a request from a board member.
just request from a board member. That's the. Okay. Everybody all right with that?
That's all right.
And Brian could be re-invited back on.
Yeah, I'm ready to come back on this.
Oh, we should have sat in here for that discussion.
He could have sat in here for the discussion, but he chose not to. So he said for the discussion, he chose not to.
Yeah.
You able to make it so that mine is on the screen there? I've got a thumb drive in on the one, and then I've got my HDMI in this one.
Sean, can you fire up his? There you
Looks
go.
good to me. Looks like he's got it. Oh, super. All right, I got to breathe quick. All right, thanks for the chance. I got asked to speak about just an update or basically a primer again on, frankly, what is probably it's been the most talked about court case issue that we've had probably in the last 5 years has been who should or shouldn't be voting on something. But I want to clarify things given that we just had a 15-minute discussion on something that primarily these comments are related to quasi-judicial proceedings. Quasi-judicial proceedings are in reference to you as a Board of Adjustment, variances, conditional uses, and the other appeals. Those are the administration of the ordinance, the thing where you're giving a direct benefit to a single person, as opposed to something that's more general legislative or rulemaking, which is not quasi-judicial. Those types of proceedings where impact of the decision relates to general matters, where the effect will be in the future and not quasi-judicial. That's not to say there's no such thing as a conflict of interest. However, there is a lot more room on that, is what that amounts to. So, and there's a lot less there are a lot less court cases on that because there is so much room on where things can go. And frankly, I can't think of an example off the top of my head in the state where something like that has come up. So, just wanted to make that clear differentiation because that's where we're at. I'm going to stick with this page for just a second, even though these 4 points show up about 6 times, I swear, throughout this whole process. I am tasked, first of all, with identifying, making sure that when you leave, you can tell the difference between the different types of conflicts of interest. And it's at this point that I should point out that what I have here, the sheet that I've got here is adapted, and frankly, this is literally taken from some of the attorneys, Jack Heeb, Zach Peterson, who are work with the Public Assurance Alliance and have presented this at the 2018 annual conference of South Dakota Planners Association. They've presented it at South Dakota Association of County Commissioners as well, and use this as the basis for how they describe things. Have told me, go forth and prosper, explain this to people. Just don't pretend you're an attorney. Tell them to call us for any legal questions. So I'm not pretending to be an attorney. I am doing my best to use my experience and things I've heard throughout the process in doing it. The 4 types, I'm not going to read verbatim. Direct pecuniary interest is where you get money from a decision. You directly get money from a decision. Indirect pecuniary interest is where someone you know or love, someone closely tied to you as a decision maker gets money out of that decision. Direct personal interest would be if a blood relative, close friend, someone like that is benefiting from something. Indirect personal interest is somebody you know might be doing well, or a club or organization you're involved in that you have no financial stake in, something along those lines, i.e. Sierra Club. Sierra Club ain't going to like my decision, so I'm going to step down. No. That is the difference. Now, I'm going to go to the presentation that I had there because that is the introduction to a lot of this in going into the court cases where we've spread through this in the state of South Dakota with a few court cases, and and I think I'm just going to I'll hit through all 5. I'm not going to read through all of them, but there are 2 things we're talking about here: ex parte communication and a personal bias. And that ex parte communication can affect your personal bias or something going on in the real world. I am going to talk about ex parte communication and what it is. That's where you take oral or written communication relevant to the merits of an adjudicatory, I can't believe I got it right on the first try, proceeding that was neither on the record nor unreasonable. Here's the point. You got information about a topic outside of a public hearing or outside of a time you were supposed to. That's what it amounts to. There have been cases, and I don't even have them in here, but there have been cases that have refined that further to say that you can be slightly more comfortable if you didn't invite it. So if you were at church and somebody came up and handed you a flyer and you accidentally caught a glimpse of it ahead of time before you went, you know what, just bring that to the hearing, you're fine. You need to disclose it. That's essentially what you heard. We had an example where where someone who was opposed to a feedlot brought all the voting members pies and took that time to describe while they're serving them the pie all the terrible things of that feedlot. And ultimately, that board did vote no on that one, and even that decision was upheld and said that they did not have ex parte communication because they didn't invite it. Now, did they ask for a second piece of pie? Maybe they did, and if they did, maybe that's far, but whatever. I'm not going to get into that. So there is a difference between stumbling into something and calling up the applicant and saying, will you tell me about this before the meeting? Those are 2 different things. The first and seminal case that we really refer to a lot in this context is the Hanig case. I really don't want to dive into these because at 9:30 at night, no one wants to hear someone regurgitate a bunch of court cases. But what I really want to hit on are the track that get us to where we're being told to go today. And this particular court case was just a liquor license being issued by a city. One of the waitresses at a competitor was also one of the people on the council. She wound up voting no throughout a lot of testimony. It was determined that it would have been very difficult for her to go about her daily job without being suggested or understand the negative influence of having a second bar in town would have on her employer. Thus, proved the hearing was not fair and impartial. They only needed to show an unacceptable risk of actual bias. And the most important thing to underline there is the unacceptable risk. We're not looking for an aha, gotcha moment, you were biased. They're just looking for, is there a chance for that to have happened within that case? Is there a reasonable chance for that to have happened, is what that is. Now, so we've gotten to that point of there's an unacceptable risk. But what is bias? And that's what the rest of this presentation is about, okay? Here's a lot of quotes out of the Supreme Court on that frankly I'm not really going to get into other than when can I vote, and that's that the interest must be different from that which the quasi-judicial officer holds in common with the members of the public. Their interest needs to be different than the general public's would need to be. So it's showing that you're different than other members of the general public that would be up there. A great example would be, and I'm going to get into this in a minute as far as recusals, in Florence, where I'm from, there are Moggs, Schockerts, and Flemings. That's it. Everyone's related to one of those 3. So the bottom line is you can't make a decision that doesn't affect a Mogg, Schockert, or Fleming. In fact, frankly, they're all 3 probably on the board. While that's somewhat of a joke, it's not that far off. The point is that if you had to recuse yourself every time one of those 3 was making a request, we would never have a board. Since the bulk of the town is related, coattail to them. Now, of course, if they're not mom and pop, they can probably make a vote. I'm going to get back to that in a second, but I want to get to the point here. So after this whole case went on, of course, they pointed out there are all these biases. And Chief Justice Gilbertson at the time said, dear Lord, we're in a small town. He was from Sisseton. He said, I would never vote if I was on a board. I know everybody in that town. And so ultimately, he published a dissenting opinion on it that basically said that it's unrealistic to think that that's going to happen. I'm paraphrasing, but that's essentially what he said. So ultimately, this is going to take a while. So ultimately what happened was after that, the legislature had a retort. They ultimately passed this statute, 6117, that basically outlined that the direct pecuniary interest is the one we're worried about. That is the bias that we are trying to avoid, is the direct pecuniary interest that goes to you as a decision maker on the on a decision that you're making on an administrative matter. Excuse me. If it is determined that there is, say, another issue that needs to have that person recused, or even that direct financial one, and that person does not want to recuse themselves or does not recuse themselves, it takes a 2/3 vote of that body to vote to recuse or remove them from that item, is what it amounts to. It does happen sometimes, and I'm going to get to where you can actually use that to bolster the reasons for having that person in there as well in just a second here. The summary, this slide is just a summary of that Hanig case one more time. But again, the important thing is board members should only be expected to recuse themselves when a reasonably minded person would conclude that that official's interest in the matter had the likely potential to influence his impartiality in its resolution. Basically, that my personal bias led you to do something different. And what it went back to was your personal biases, we all have some in certain cases, but it's more about your financial gain is the one that is a clear cut. That's going to be tough to argue against. There's another case that did come in with ex parte communication that I'm going to talk about because this does affect you in, say, issuing permits, and it's more about trying to make sure you're not furthering an agenda of your own personal agenda. In this particular case, this one Armstrong versus Turner was a case where zoning officer issued a building permit that should not have been issued according to the zoning ordinance, figured out, oops, I screwed up. Now we got to do a conditional use permit on this. And the neighborhood was livid, did not want to see this elevator go in. And ultimately, after hearings and meetings and of the county commissioners and the board members in a closed door setting with the people that don't like it and the people that do, trying to bring everyone together, one individual had pointed out even throughout the process that he was just trying to keep the county from getting sued. And so ultimately that person voted to approve, made the motion, and voted to approve that permit. And it was determined that through the testimony and the past actions of that individual to bring everyone together trying to get this thing to a resolution that resulted in the county not being sued proved that his motivation was not, or at least there was the unacceptable risk that his motivation was not to follow the ordinance necessarily, but to keep the county from getting sued. And so ultimately, that was enough to throw out that decision. And ultimately, I don't remember how that one ultimately wound up, if they wound up figuring out another way to permit it or if the county bought themselves some grain bins. I don't recall. I believe the county bought some grain bins on that one. Here's the most recent one that we've had that gives, you'll notice the first couple of cases kind of slam the door shut a little bit and go, holy crap, when can I ever vote? Things start to open up now, okay? We know that we've got the ability, because of the three that I mentioned that are less apt to be an issue, the indirect and then I know somebody that might be involved. Those are less apt to be an issue. Now we get down to the direct pecuniary one, and that's what Holborn versus Dual County was about. There were four, well, actually they alleged that everybody was biased. Everybody had a problem, but the judges, the Supreme Court and Circuit Court judge threw out the first argument, which was, well, these guys historically have always stood beside wind towers because they voted for the ordinance itself, and that points out that they're biased for wind towers. They want them. Well, it's a legislative act. Yeah, I mean, people have, just because they voted for something in an election doesn't mean that they should never vote on anything else ever again. And that's that it disqualifies them for a permit. And that was that one. But the ones that were interesting were there were 2 members that were signed up for easements with that company and had received payment in the past. However, they were no longer. They backed out of it when they found out, crud, I'm on the board. I can't be a part of this. They backed out of it. There was one of the board members was a minority owner in a company that could make wind tower components, albeit may not make wind tower components for this group. And there was another one whose employer had wind easement. Ultimately, the only 2 that were disqualified were the 2 members that were signed up for easements and had received payment in the past. The Supreme Court reinstated their votes. And the reason they did is that they basically relied on a U.S. Supreme Court case that involved a judge in Pennsylvania where an exorbitant amount of money was contributed to the judge's election campaign from a defendant with a case pending before the would-be judge. Here's the story on that one. Basically what happened was there was a guy running to be judge in a judicial body for an election, and there was a case due to come before that court. The defendant in that case donated, I believe the number, and it's just stupid to think, was $10 million to his campaign for a judgeship in Pennsylvania. And it's a lot. We're dealing with monopoly money, but when you think about the fact and what they said in there, the next highest contribution to any individual that ran, including him or anyone else, was in the neighborhood of the tens of thousands. So it wasn't just that he got $10 million. If everyone else had gotten $10 million, that would have been a different case, albeit it might have turned out the same way. It was that it was so crazy, the amount that it was completely different. And that's what they relied on this was that they didn't go out there and say, I need this, or they didn't, hey, I'm a board member, come sign me up. When they figured it out, they got out of it. Yes, if they were going to get that kick in and they were going to get that multiplier the day that permit was issued, absolutely. They have a direct pecuniary interest, they're going to get more money, absolutely. But in that case, what they said is they had the same ability to get that as anybody else in the county. And when they found out it wasn't there anymore, they got the heck out of it. So they were found to be just fine there too. A couple of things that come out of that, though, are because I sat in that hearing as it went on, and this is the point I'm going to step out of my presentation and just talk about it for a second, and I'll talk about how to in just a minute. Some of the things that we relied on that actually helped are things that you do. Prescribe an orderly procedure for your meeting, and you prescribe time limits. Stick to them. You're allowed to do that. Supreme Court has stood by that time and time again. The board performing its duties in past cases, such as legislative actions, does not create a bias. Just because you said we should have this rule and then someone follows it doesn't mean you were biased toward that rule. It means you made a good rule, or at least one that was being followed. Failure to read every piece of written material, this is just always good to restate. Failure to read every piece of written material, in this case it was 518 pages, which were submitted, does not indicate that you had bias because you didn't feel like reading 518 pages of stuff that was flopped on your desk the day of the meeting. You can vote, prepare findings, make permit, effective date start on agreement of conditions, which is not related to that, and then the other part about special exceptions. The thing that we did in that meeting, though, that I think you need to keep in mind as you go into the future, there's a couple of points. When you do that beginning where it's a disclosure of potential conflicts of interest, in communities where we're at, I always tell people we probably ought to have pretty much every application someone say, I know this guy or gal, but it's not going to affect my ability to vote. Or I bought a car from him in 1972, but trust me, it's not going to affect my ability to vote. We should probably have more of that, more disclosure on that than less, just because it's better off to have that than the other instance where someone's left to guess this one here, the third point on that. The more disclosure of potential conflicts, the better. It gives the judge more to consider rather than pure speculation. And my point to that is, don't let the defendants, or don't let the petitioners write the narrative. Just tell them why you're voting. Or, otherwise it does pose the question, why didn't he bring it up? Why didn't she bring it up? That's it. Not to say that there isn't a valid reason why you didn't even bring it up, because you know as well as I do, 9 out of 10 times you don't bring something up. It's because 1, you didn't think about it. 2, you're like, there's no way this is going to affect anyone. Nobody cares that in 1982 I took this girl to prom and now she's asking for a variance. That's the thing, is that most of the times it never even comes up. It doesn't even cross your mind that someone would think about it until that comes up. But at any rate, those are the couple of examples. But what we wound up doing in that meeting was we wound up going through all of the potential conflicts. And this person has a potential for this person has a potential for this. And that particular meeting, Jack and Zach were there, Peterson and Hebe were there, and they recommended every time someone mentioned something, and I'm not saying you need to do this on every single item, but every time someone came up with something, they asked for a motion to remove that member. And the reason you do that is because if that motion fails, well, then the board clearly agrees that that person should be voted. And guess who makes the rules on who decides gets kicked out? You do. So the point is, if you're not sure as a board, and I'm going to say the same thing on the other side, if you're someone who had to bring that up, that I did sell hay to this guy last year, but I can still make the vote, don't take offense to the idea that they do make that motion, because in reality that would be the safest way, would be to make the motion to remove that person, and then that person who makes that motion just automatically says, I don't think we should remove this person, but I feel like for the record we should all vote no on this and allow this person to stay. So that's the safest way to handle that. That's what comes out of these guys. They actually said to word the motion differently, but however you word it, I don't care. Just vote on keeping that person in there if you're not sure. That's my suggestion, if you feel that way on it. When can I vote? Whenever your attorney says so. I mean, that's when it comes down to it. If you're not sure, double check with the attorney. In going through here, I've got a lot of examples in here that, frankly, I know I've gone through in the past with you. I've got examples of how to go about just stating that you have or haven't talked to somebody outside of here, and how to handle things. We've got some best management practices in there as well. How to handle site visits. Supreme Court's never weighed in on them. But the main thing that you want to keep in mind as you're going out doing your job, checking on these things, 1, ideally you rely on your staff. I'll be honest, I couldn't do that if I were in your shoes. I'd be one of those guys going out there checking on these things too. The main thing you got to keep in mind is that make sure that you're not getting information someone else from the general public couldn't get. So you're not driving up, you're not driving up into the driveway and asking, hey, Joe, tell me all about your application. No, if you're checking from the road, oh yeah, that is pretty close. Things like that. That's the sort of thing that it seems to be within bounds, because anybody from the public could swing by and do that same thing. But in the same breath, don't 3 of you go do that at the same time or anything like that. If there's something you want others to, maybe you drove out to the site and you saw that, oh gosh, that's a feedlot and there is a waterway right there, and it doesn't show up on our map. Rather than you call Neil, call Richard and say, Richard, would you go take a picture of that, because I want that to be brought up at the meeting. And so or I want you to forward that on to the board if you would. Don't go person to person on that sort of thing. That's a big no-no. With that, I can happily take any questions. I really felt like the most important thing to get through there is the direct pecuniary interest is the one that is a big no-no. The rest of it, I'll be honest with this board, I have noticed more often, you guys recuse yourselves more often than you, in my experience and what I've been told, really need to. And there's not a huge problem with that, especially since you guys usually have alternates here. So it's not a huge deal. I'm just telling you guys are more often than not more cautious about it than anyone else. The one that's always been entertaining to me is the instance where somebody recuses themselves and then someone makes a motion to say, no, you can't, or something like that and forces them to stay. Because I think that is an option in there, but I think that'd be a fun instance. But I'll leave with the last brief war story of one that was somewhat entertaining. The only case that I've had similar to this in a permit standpoint was one where I'm not going to say the county, but people will figure it out, I'm sure. I might be far enough away that maybe they're not watching it right now. But we had an application for a feedlot by the zoning officer, actually. He applied for he applied for a feedlot permit and required a conditional use permit. And just so happened that the chair of the board, 5-member board, was his brother-in-law, in which the brother-in-law's wife was adamantly opposed to the feedlot, ironically. There was also a cousin of his also sitting on the board. At the meeting, when we had the opportunity to disclose potential conflicts of interest, everyone shut up. Nothing. We had nothing. Nobody said boo. And in part, it was due to the nature of the way they were reading the question, and so that's where it's kind of important to start that language too. The way that they read the question was, does anyone have a potential conflict of interest that might bias you in any way on this vote? And so after the meeting, when the cousin of the applicant called out the brother-in-law that he shouldn't have been voting on it because he had a conflict of interest, whatever, despite the fact that the cousin didn't think he had a conflict of interest in it, the guy said, well, it wasn't going to affect me, so I didn't bring it up. That's the example of you need to bring it up. Just bring it up, air it, just say, I'm on the board, I'm able to be partial on this, I'm not getting any money out of this, I'm not going to be getting better Christmas presents out of it. Frankly, I probably will be getting worse out of it based on my decision, but it's not going to affect my decision. At that point, at least the board would have had the opportunity to vote to keep him in or not. And hell, they may not have even made a motion. They might have just said, it's fine. What you said is right. And knowing that board, they would have, because I know one other time they let a guy continue to rag on an applicant because he refused to pay him for some drainage easements or whatever on his land as part of voting on it. So the bottom line is they didn't kick him off either. So that is the only war story I've got. I just thought it was an interesting one, but it's an example of just go out there and just know that even if you're not sure, because at worst, honestly, the best case is for you guys to uphold that member's validity in voting, is what amounts to. So that was it, and that was a message I kind of want to get through for about the last hour, but that's the main point. So again, I'll back off. That's all I had.
You can drive
Right.
past it, but you shouldn't get out and go up and physically inspect and walk around
Right.
there and ask questions of the construction workers or the applicant there.
The other site visit one that's come up in the past is it may be a feedlot situation or something like that. And the applicant has another feedlot somewhere else they'd like you to see because it's so clean and nice and new. And they'll offer a bus trip for you to go over and look at it with some other people. That's a no-no. To
Yeah,
jump on the bus and run over there and look at it, their presentation prior to. You could drive over there, drive around the facility and come home. But if you're taking an argument from them or a presentation from them, that's inappropriate.
we hear that a lot. There's some of these things are going on now that I really don't like. But I mean, it's in the same breath. I get that they want to invite the public out and the kind of hiding behind that. I've just seen enough court cases where it scares me on that, where you're disqualifying a voter. Because there is the common belief that you could maybe publish that as a meeting on site. I wouldn't do it. I really wouldn't. Like you said, it just, like we said, I had a state's attorney I used to work with a lot that makes some decisions, we'll say, that are relating to this now. And what that person told me was that if you can avoid a legal question on the front end by simply not doing something or republishing it, when you know there's a clear answer as to how to not have that brought up, take that route. It's way cheaper than having me, attorney, quoting her. It's way cheaper to republish that or to just avoid it and have Richard go to that site and do a report than it is for me to have to litigate that for 3 months. So that was the point. The other one that I've seen a lot, and just now this is more for Commissioner Bartley, but also that you guys I'm sure will get at some point, that sort of thing, is I'm seeing cases where a company will come into town and they want to tell you about how great they are or the things that they do for the community, or that, hey, we've got this big project and we just want to give you a heads up that it's coming, and here's what we do and here's some generals about it. Well, guess what? You just did that on an agenda you did that without a public notice. You just took testimony from them. And so what I tell these people is that, yes, you do have that ability to go on and open, but everyone else does too. That's why in a lot of our counties, we recommend having within your bylaws specifically for the Planning Commission and Board of Adjustment that any item which may come before the Board of Adjustment, you are not eligible to address us on the open, and we'll take that fight later on because we're going to fight it on the other end if we don't. Same thing is true. The part that's scary to me for county commissions is that Commissioner Bartley has to sit there because he's a county commissioner and he's also on this board voting. So there you go. You got one right there that we're going to have to argue about, or else he's got to just walk out when that person walks in the door. So those are the things that I'm worried about seeing coming up. That said, my job is to be the canary in the coal mine. So that's it. Now that it's raining, should we head out?
Department reports.
Thanks, Luke. What you did there, we have a couple, I've got 3 quick things here. From the May 12th derecho, the county commission rescinded building permits and inspection permits till December 31st, 2023. We're having a few come in. Question just to clarify this. They want to rebuild their building that was destroyed a little larger. So do we charge them for the building permit above and beyond what their original building size is for that square footage? Let's say the original building was 50 by 100. Well, now they want to rebuild it. They want to build it 60 by 150. So do I take the difference, the percentage that much larger, and charge them the fee for that? Okay. Then the other question is, it blew down at their farmstead where they're at, but yet they want to rebuild it across the road in their pasture for a calf shelter. Yeah, that's why we're asking it this evening, so.
I would say if it's on the same site. Yeah. And even if the footprint changes a little bit, you know, an old barn from 1910, you're gonna build something bigger. You know, maybe not the same exact footprint, but you're gonna have it on the same spot.
Right, that's what it is.
Yeah.
Right, or that's just the example I used. If they want to put it over another bin site or another area there.
Maybe if they moved their whole livestock operation across the road after the first building was built, maybe, I don't know.
I guess I would take into consideration the hardship that they've endured through the duration and the cost that they incurred. What we're trying to do is make it a little bit easier for them to rebuild. I don't know how much of a difference in the building permit we get matters. If I go up a little bit, if it goes across the street, it's still, you know, it's a permit. Is there extra work involved if it's across the street versus if it's on the same
Where it's-
site?
Correct.
You know, so to me, if we're trying to be a benefit to those who were harmed, we just don't charge a permit unless it's a new building
Right.
that wasn't destroyed. If they had one destroyed. I mean, there's hardship there, and we're trying to be, you know, helpful.
Okay.
That's probably true. The building costs.
So
So if it's a small part that we can do, I don't have a problem.
right, that's how we would do it. It'd be just this.
Simply because a lot of the projects wouldn't get done.
Just in a different location.
Luke, what do you think?
I think it's a great question.
I think you,
If
You
the only
go-
thing you're, the only thing you're dealing with is just the fees for the, just let them do it.
go building for building plus 10%.
Actually, that figure 10% of the value.
10% of size, square footage. I mean,
Yeah.
if I'm gonna replace a 30 by 40 with a 80 by 240 on the same building permit, trying to get that through, that's not right. But if I'm gonna replace a 50 by 60 with a 60 by 60,
They
Fair
can
enough.
they can enlarge the building by 10% is what you're
Yeah.
saying.
they can
Enlarge the
enlarge
front.
their building by 10%. And if they're not gonna rebuild it here, they can rebuild it across the road and call it even.
I like the 10%.
It allows fairness to expand, but it controls the tripling in size.
I mean, I think that what was going through my mind was there's a difference between looking there and see that 36 by 36 garage was knocked down. I'm just going to put it over over here now, and maybe that's not a machine shed. 40 by 60 machine shed was knocked down there. That's why I built that 200 by 300 over here on the other side of the road, versus it was always a horrible spot. This always was better. And they built the same one over there. I honestly, that is probably the simplest way to do it, is you give them just a grace from the standpoint of, might be a difference in, be it sidewall, might be a rafter distance. Lord knows when it was built, you know. It's probably a good way to do it. Yeah, giving a little bit of grace.
So what about replacing two buildings with one?
Okay, so they can rebuild another location and 10% grace, and anything above that, charge them for. Yeah. Okay.
Said I was my permit. I lost two buildings. I'm just wondering where my line is here.
All right, the other one we have a question on, last year we did a home extended business for a gentleman over by Volga, for that UTV place. We did have him go through and through the Department of Revenue get a license for that. We had manufacturing and vehicle accessories is what we allowed him to do. He called the other day, and this come from Department of Revenue also. He's looking at adding trailers to his business. Could be 2, 3, no more than 5. But would that fall underneath his existing pull behind, just, utility car trailers or that type, small trailer type thing? To haul the UTVs is what I'm looking at. And be no more than, he said, 5 would be the most that would ever be there. A lot of them they would be sold there and gone, Right, he has the, get another conditional use to sell trailers, or do we fall that under his existing conditional use with vehicle accessories and the manufacturing of his UTVs?
Right.
Depends on how big he makes them, that would be.
I don't know if I got 4 UTVs, I'll buy one. Mm-hmm.
Yeah, that's what he had.
Yes, I would think as long as the trailer's for the UTVs, then no big deal.
UTVs or other UTV equipment type stuff, not necessarily his, but yeah. Okay.
As long as you can keep it classified as an accessory.
Okay.
I have a hard time putting that UTV inside a cat box.
Depends how big the door is.
The other thing I had, I don't know if anybody else made it to Dakota Layers open house the other day. I went on Monday. Just took a few pictures while I was there. I'd show that to right now they've got one building. This is the one side where they come in. Chicks are on the floor right here. These are little feeders, that conveyors.
I know, I was thinking that too.
Conveyors are there that the chicks feed on. As they grow, they go up to, these are the roosts right here. This is the conveyor system that comes down. The feed comes down there at the one end. Conveyor's always running for feed on there. And as the conveyor returns back, they have a ramp on here. So when the little chicks get on here and ride around thinking it's fun, they came over here off the ramp, then they'll get looped off and away they go, so they don't go around the circle and squished in the feed conveyor. This is the nest, the roost series that they go on. There's little bars on here. As they grow, they'll learn to hop up. These yellow things back in here are the nests where they go in. They're open up. These doors open up at night. The lights dim just like daylight. As the day goes on, as the evening goes on, the lights will get dimmer. The lights will go out, and they're supposed to go in and lay their eggs in the nest. In the morning, they get gently plopped out of there, go out, run around, and eat and whatnot. And the night, then they'll roost up on the roost. There'll be other pictures here. Up on top here, there's 4 roosts, 4 bars that they can roost on up there and or here when they go. That's just the end of the feeding conveyors on there. In the roost, in the nesting area, there's 3 conveyor belts, 3 layers that take the eggs down to the end, put it in a conveyor, goes around, and they go into a pallet. It's all palletized on there. This is the south side of the building. This is where one of their runs will be here. Going to be seated this fall. Ventilation fans going across here. Everything is. No, they will be covered with chicken netting over that, with netting, just like they have in pheasant farms. If it's under so many degrees, the chickens will stay inside. They won't go out. So, depending on temperature dependent, to be determined what temperature that is. So this is the back. This is where the litter is stored. Basically, they have 2 gutter cleaners. I can show you that in another picture. That can clean about every 20 minutes. That goes and makes the cycle out from underneath there, and then goes back, conveys it back to here. And there's storage here for about 6 months to a year. They plan on cleaning this out twice a year. So this is where the feed is stored there. This is to the north of the building. There's some stakes out there, but this will be the other run right in this area. So this is just bigger part. You can kind of see a pink stake right there. That's the fence going down. This is just where the gutter cleaner comes from each side. This is where it goes out to that back room. So, and this is their chickens they had populated in there. You can see the roost where they stay, where they can roost on at night. So, there's the 3 different breeds of chickens they're going to be having. So, they stood still too. They didn't run around. So, this is the runs where they go outside. They'll manually controlled. Everything's computer controlled. Lights, feed, ventilation, and all that. So, pretty interesting. So, that's all that I have, I believe. So I think that's all that Bob
You
had.
can get
So
a picture of the really good looking bean field right outside of that.
tried. That's probably the one I had it on video and didn't realize it,
Yeah.
because that's I had the front of the building and where the eggs were. Well, I had it on video, and then the rest of it was pointed towards the floor, looking at my feet. So.
Oh. Mm-hmm. It's a new thing. They're adapting.
I know.
Yep.
Yeah.
Yeah, about as they go, about 12 weeks is when they start laying. They get in it each week. They grow. They just get them trained on there. To
6 months.
so, anyways, pretty interesting tour. So,
To get my chickens too, after I buy them.
Is that it for department reports?
that's all that I have, I believe.
Is there any need for an executive session?
Oh,
For motion to adjourn?
so moved.
Motion by Diedrich, second. Second by Banner, meeting adjourned. I don't need a second on that one, do I? Oh.